So what I'll do, I'll introduce our speaker today, and also what I want to say is please put any questions that you've got either into the chat or the Q&A, and we'll deal with them all at the end. And yeah, Emma's win. So Emma's my colleague here. Her dad finally came out of hospital after 43 days. Oh, such a
Brilliant.
relief, Emma. So, so glad that's finally happened. In fact, my mum came out of hospital after a much shorter stay as well. So that was good news. Right. So the other thing I'm going to say is Mike here has his connection is a little bit wobbly. So we can see Mike now, but as soon as he starts sharing his screen, he's going to disappear. But he'll come back on again after he's done the presentation. So that's why you won't be able to see him. But Mike is one of the co-founders of Crofton Bradfield Tax, specialising in IHT, estate planning, succession planning. So really all those issues that we're going to be talking about today. And he works very closely with accountants, sort of helping to kind of optimise tax planning opportunities for your clients. So I'm just going to say, I've got a couple more wins of the week. Joanne, youngest son, passed his driving test. Yay.
Yay.
And Vin is hearing you loud and clear in trips. Okay, I have to start calling Tripoli trips. And what else have we got? Tracy, win of the week, a new client who looks like they'll be an A grade client. That's really, really good. How exciting. Anyway, right, what I'm going to do is hand you over to Mike, and he is going to start the presentation now.
Cool. I'll just share my screen. Maybe Susan, if you can let me know if you can see that or when you can.
Yeah, that's great. Yeah.
All right, cool. All right, well, hi everyone, and thanks for joining today. You know, as Susan has said, my name's Mike Pritchard from Crofton Bradfield Tax. We're a chartered tax advisory firm. Our expertise lies in IHT and estate planning, and so today's session will focus on the practical aspects of how including pensions in an IHT estate from April 27 impacts the wider estate planning process. We're not going to provide a deep dive into the legislation. I think most people know the change is coming and broadly what those changes are. My objective is really to share some of our thoughts when we look at a client's estate and some of the triggers that I think create advice opportunities. The presentation should only last actually about 15 to 20 minutes. So there's going to be plenty of time at the end for questions or for those that want an extended lunch break. Okay, so I think the key message really is that this isn't just a 40% IHT charge on unspent pensions. Bringing pension wealth into the estate can change the whole estate plan. As we know, from April 27, most unspent pension wealth will come into the IHT calculation. We also know that the age 75 still matters because the inherited pension income tax rules remain relevant. The interesting planning points are how these changes interact with allowances, especially something like the residence nil rate band, and how they can create liquidity issues where pension assets are not readily available as cash. So I think the big message really is this isn't just a pension issue in isolation. It has a much wider impact on the estate planning process. So as I said, I'm going to keep legislation light and focus on practical points. We'll start with a reminder of what changes from April 27, what remains outside scope. I'll then use 4 case studies: A75, the residence nil rate band taper, SASH commercial property, and unmarried couples. Within those examples, we'll look at things like spousal bypass trusts and other examples of why the changes are more than just 40% IHT, before moving on to wider planning responses and how I think accountants are really well placed to start the IHT conversation with their clients. Advance warning, the case studies are really simplified. The objective is to highlight the issue and not to cover every potential angle. So I think the pre-27 position is familiar. You know, where pension scheme trustees or administrators have discretion, then pension death benefits are often sat outside the estate for IHT. That's why pensions historically have been often preserved until later in retirement and also used as a succession asset. However, for deaths on or after the 6th of April 27, that position changes. Most unused pension funds and pension death benefits will be included in the estate for IHT. You know, a nomination can still influence who receives the pension, but it will not usually keep the value outside of the IHT calculation. So the obvious area to review is really unused pension wealth, particularly defined contribution pensions. We're still going to have some important exclusions and protections that carry over. For example, the spouse and civil partner exemption will remain available where pension benefits pass to a qualifying spouse or civil partner. Registered scheme death in service benefits will be excluded, and some continuing survivor annuity payments may also fall outside of scope, depending on the terms. But this is the main conceptual change. You know, we now start with the free estate, including property, investment, cash, and business interests. And then from April 27, we add the relevant notional pension property. That gives the combined estate on which IHT is calculated, including the amount for the pension element. The personal representatives are responsible for settling the IHT bill, which includes the responsibility to track down all of the pensions of the deceased. You know, and that's quite an issue for some people, not knowing whether they've got old pensions knocking around from many, many years ago. So as part of our advice process now, we provide our clients with access to a policy tracking service that can help locate things like lost pensions during their lifetime, which is designed to make it easier for the personal representatives on the death. And as mentioned, we're not really going to spend any time on the sort of mechanics from an admin perspective, because I think the planning points are more important. You know, as a business, we deal with lifetime planning, so our focus is now on how the changes will affect things like the will, pension nominations, and the wider estate plan. First case study. The first example separates the new IHT rule from the existing age 75 income tax rule. Here we assume a £1 million pension, no available nil rate band, and non-spouse beneficiaries. If death occurs before 75, we assume 400,000 of IHT, leaving 600,000, which can normally be received income tax free. If death occurs from age 75, then the income tax position changes. And if the remaining 600,000 is drawn by a 40% taxpayer, whether immediately or over a period of time, that creates a further 240,000 of income tax, leaving 360,000 as a net amount. So age 75 is not really an IHT cliff edge. It's the cliff edge where the income tax treatment results in double taxation. And having spoken to a number of the financial advisors we work with, I think it's really going to be vital that clients get some advice on whether the pension they have is set up in a way that allows beneficiaries the time to time their income withdrawals, essentially. And I think this is one of the reasons why the change is harsher than the headline suggests. You know, the government's broad message is that pensions are being brought into the IHT estate, so they are treated like other assets. But the reality is they're not really being brought in on the same terms. First, for those that die after 75, there is IHT and income tax. In our example, the overall taxation is 64%, whereas other assets are generally limited to 40%. Second, we've got loss on sale relief that doesn't apply to notional pension property. For example, if a pension investment falls in value after death, the estate can't claim the normal IHT loss relief that may be available where qualifying investments are owned directly. Third, we've got this 10-year instalment option that doesn't apply to the pension element. For example, if a SAS owns an illiquid commercial property, the IHT attributable to the pension can't simply be spread over 10 years in the same way that can apply to certain directly owned land or business assets. And finally, business relief and agricultural relief don't apply simply because the underlying pension assets would otherwise qualify. A good example here is a SAS owning the trading company's premises. If that property were owned personally, it could potentially benefit and qualify for 50% business relief, whereas if it's held within a pension, the pension value doesn't qualify. So yes, it's clear unspent pensions are entering the IHT net like other assets, but also clear is it's certainly not on the same terms as directly owned assets. I think this is the most important numerical example of looking at the residence nil rate band taper trap. If we assume a widowed client with £1 million home, £1 million of investments, and a £700,000 pension. If we assume there are 2 lots of nil rate bands and residents nil rate bands available on second death, with the home passing to direct descendants and death before age 75, then before in pension inclusion, it's simple. The estate is 2 million, relief is 1 million, and so IHT is 400,000. From April 27, the pension takes the estate to 2.7 million. That's 700,000 over the £2 million taper threshold, so the full 350 residents nil rate band is lost. IHT is now 820,000, which is an increase of 420, all because the unspent pension value removes all of the residents nil rate band, and of course because of the IHT. Or in simple terms, looking at it as a family will, a £700,000 pension has a net value to the estate of 280 after all of the tax consequences, or 40%. This case is about liquidity. Here we're assuming a SAS is worth 1 million, 900,000 is commercial property occupied by the family trading company, but only 100,000 is available in cash or investments. April 27 comes along, the pension value forms part of the IHT estate, but the pension doesn't have the cash to fund the tax. So where does the cash come from? We could be looking at a forced sale of the premises, and that might have a disruption on the business itself. It could be looking at refinancing, which may take time, and the property may also just be a very difficult property to sell quickly, dependent on market conditions. And I think this is where the lack of the 10-year instalment option for the pension element matters. And therefore, for SAS and SIPP property clients, the review probably needs to cover things like valuation, cash reserves, borrowing, possible sale, timing, and business continuity on a regular basis. This is the last case study. This is regarding unmarried couples. This is a very clear practical change, and very much recent in the headlines recently with 𝐬𝐮𝐫𝐞𝐿. Before April 27, Ricky could nominate Jane, his long-term partner, to receive a pension death benefit, and the pension itself would normally pass to Jane outside of the IHT estate. If death was before 75, it could normally pass without income tax as well. But from April 27, the pension comes into the estate for IHT. And so in our example, Jane may still be nominated as Ricky's beneficiary, but an unmarried partner does not qualify for the spouse exemption. So that creates a very clear divide between marriage and non-marriage, as it creates a 40% IHT exposure. Whilst we're not sort of presenting marriage as a tax product, it is clear that relationship status is now having a much more important impact for estate planning purposes. And the same logic, almost in reverse, applies to historic spousal bypass planning, trust planning. Before April 27, a bypass trust was typically put in place to receive pension benefits because it provided control and protection while the pension wealth remained outside the surviving spouse's estate. And trusts still have a valid non-tax purpose. It's going to help with things like remarriage risk, family disputes, or control over wealth. But I think the tax logic and perhaps the point at which a trust is used is going to change. If pension assets pass into a discretionary trust, then we're looking at a potential 40% IHT charge on first death. If instead it passes to a spouse, it's likely IHT free, which gives the surviving spouse time to consider things like gifting, trusts, business relievable investments, and so on. So I think the key message here is that there is a planning point to check historic nominations and to update if needed. Also, a common approach historically has been to spend non-pension assets first and preserve pension wealth, and that made a lot of sense. Pensions could grow tax-free or tax efficiently and pass outside the estate. From April 27, that default probably needs to be challenged. It doesn't necessarily mean that clients should simply draw pensions faster. The better question is, what's the most efficient way for this client to fund retirement? And looking at the estate as a whole, what's the best way in which to transfer wealth and which wealth to transfer first? And that requires tax modelling and likely involves various advisors. And I guess the main point here is that you guys sit in the middle with the client, But the pension change itself doesn't sit neatly within one professional discipline, and that's because it has a wider impact than just the pension. Our role as a business is to deal with the tax and estate planning aspects, but we typically work alongside a financial advisor who may need to consider pension strategy, retirement income, investments, or protection. We can work alongside a solicitor that may need to deal with the will, updating the will, trusts, or other legal documents. I think the important thing is that the client ends up with one coordinated plan, and I believe that accountants are very well placed to facilitate that. And that's because in many cases, you hold the longest standing and most trusted relationship with a client. You understand the family, the business, the property, and the wider financial position. I don't believe clients expect you to provide all of the advice yourself, but I do believe you have the best opportunity to spot the triggers, to start the IHT conversations, and then bring in the right specialists where needed. And IHT, no doubt, overall is a massively hot topic. You know, clients want access to advice, and in my experience of working with accountants, they really appreciate those firms of accountants who adopt a proactive approach. So a little plug for us, I guess. You know, what does our own inheritance tax planning review process involve? The first thing we start with is reviewing the whole estate. That might sound obvious, but a lot of people typically look at just one aspect. We look at the whole estate. You know, we'll quantify and model the current exposure, including things like pensions, nil rate bands, residence nil rate ban, business relief, lifetime gift, trusts of future growth. We then look at how those assets are held. That might include things like investment property, partnerships, companies, portfolios, family businesses, pensions and trusts. And then only then do we consider what could sensibly change. That might involve advising the client on lifetime gifting strategies, putting trusts in place, restructuring assets so they sit within family investment partnerships or companies, property restructuring such as incorporations, although that in itself probably provides a bridge to more inheritance tax planning options, but not changing the IHT position in of itself, business succession planning, or even just a better use of existing exemptions. Our main objective is not to create complexity or to put every client in the same box. It's primarily to identify tax planning that's technically sound, commercially practical, and aligned with the family objectives. And I think these are really, I guess, practical next steps for all of us that deal with clients that might have inheritance tax needs. You know, the first thing is to start the conversation with clients that are most likely to be affected. You know, that's going to include clients with significant pension wealth, estates approaching or exceeding 2 million, buy-to-let property investors, business owners with SAS or SIP assets, unmarried couples, and clients with older pension nominations or historic estate planning in place. The simplest question we find when we ask clients is, have you reviewed what April 2027 pension changes mean to your wider estate planning? That question doesn't require you or any of us to have all of the answers. It simply opens the door to a proper review. You know, where specialist advice, where specialist support is needed in terms of tax, we can support you with that and IHT reviews. And in my view, the key really is to identify the issues early while there's still time to plan. That's as much of the presentation as I think we need today. So the final message is probably as simple as this. You know, from April 27, pensions need to be considered as part of the wider estate, not in isolation. I think accountants are very best placed to identify the clients who need the advice, and I think that creates a real advice opportunity and added value opportunity for you guys, because the value you can add is not necessarily in providing all the advice yourself. I think it's in recognizing the issue, starting the conversation, and making sure that the client gets the right advice from the right people at the right time. So that's all I've got to say. Thanks for the time, and obviously happy to take any questions. I'll come out of that now, Susan.
Okay, that's great. Thank you, Mike. Yeah, if you stop screen sharing, and then you should pop back up again. I think loads in there for people to think about. We've got one question, which is, are you happy to share your slides? Because I can upload them to the Accountants Know-How Club afterwards.
Absolutely. Yeah.
Okay,
yeah,
that's
absolutely,
great.
no problem.
Yeah. Yeah. So it's obviously a very complicated issue. Lots to consider. So yeah, please just put your questions either into the chat or into the Q&A. Okay. First one is, what's your email address? So I was just about to say.
I like that question.
It's an easy one.
It's easy to answer. So.
Yeah. Yeah. If you could just put that in the chat, and then, yeah, because obviously every case is going to be individual, isn't it? With this, there's no blanket sort of one size fits all.
No,
solution.
and I think that's a really key and important point to make, really, Susan. You know, yes, there are generic things which are the same for everybody. You know, the changes in legislation are essentially the same for everybody, but the impact of those changes in legislation are different for a lot of people. So yes, there are some common tracks and rails that we run down, but the review is the most important part initially. It's really giving people an opportunity to understand and putting them into a position where they understand what actions they could take and the tax consequences of taking those actions.
Yeah, absolutely. I've just seen Tony, I can see you've raised your hand. If you've got a question, if you can just type it in either to the chat or the Q&A, that would be great. I'm just going to check if we've got anything in the Q&A. I can't see anything yet. I think everybody's still mulling it all over and thinking, I mean, you're sort of happy to go into a bit more detail, aren't you, on any of those aspects? Okay. Oh, so Terence asks, does the gifting strategy revolve around the current allowable amount of £3,000 or larger gifts?
Typically larger gifts. So what clients, and it depends on the asset that they're looking to gift, because there's, again, it gets more complex from here, because you know, gifting, let's start again. There is theory versus practicality. Okay, so the theory is, I've got assets, they're valuable, I give them to my children, I survive 7 years, and they're their assets, no longer in my estate, and therefore we've navigated IHT. The practicalities that kick in to make that more complicated are, what's the asset being given away? If it's cash, yes, that's fine, as long as you're willing to lose control or ownership or benefit from it, because you've got the gift for reservation of benefit rules that you've got to navigate. You've got the pre-owned asset tax rules that you've got to navigate. And also, if it's not cash and it's, for example, an investment property, then you've got capital gains tax that you've got to look at. So all of these things are hurdles. A large part of what we do with clients is modeling different approaches and the tax outcomes that apply to that. So the simple answer, Terence, to your question is, it's typically significant gifts that are being considered, because a lot of our clients have significant value in their estates, and £3,000 a year that, you know, they kind of have to live until they're 200 to make any impact in that. So we're looking at modeling the best way in which they can gift value to the next generation.
Great. Hope that helps, Terence. Okay. Yep. Anybody else got any more questions? I mean, have you, in your own business, have you found any particular questions coming up, Mike?
We've got another question.
Oh, have. Can a widower will pensions to children?
Yes, but it's going to be taxable on at 40%, because there's no spouse left in order to get an exemption.
Okay. Yeah. So yes, are there any particular questions you're seeing from, say, your own clients that are coming up?
I mean, a lot of our clients are buy-to-let property clients. So a lot of pension planning is, you know, their pension planning is smaller in terms of pension and bigger in terms of property. So we're just getting a lot of clients coming to us because they've heard about these changes. You know, they've heard pensions coming in, they've heard changes to businesses, they've seen the stuff on the telly about farms. Yeah. And really, they just want to understand what's their current position. We get a lot of questions around, what can we do with our family home? And I guess that's something that really illustrates the impact of the application of the gift or reservation of benefit rules, because a home is very difficult to give away, and we've seen stuff on the internet about you put your home in trust and all this kind of stuff. If you continue to occupy an asset or benefit from an asset, which you would do with your home because you're occupying it, it doesn't work for IHT. So all of this stuff out there, we get some guy down the pub said, my house is in trust, I haven't got to worry about it anymore. Right. You've got to delve into that. It doesn't make sense. It's we get a lot of questions around that. We've also got from another question from Terence: does IHT planning invariably involve the creation of trusts? Yes and no. Trusts have got some benefits because they provide control, and the asset doesn't sit within the beneficiary at one single beneficiary's estate. But they come with gifts into trust, come with fall within the chargeable lifetime transfer regime. So there's different rules in terms of capital gains tax treatment and also the inheritance tax treatment. Direct gifts have advantages because they're potentially exempt transfers, but they come with another set of capital gains tax rules and a different IHT treatment. So it doesn't invariably involve the creation of trusts, but it does sometimes. And what we do with clients is model both examples, and that includes the tax consequences, but also the restrictive elements of taking one course of action and the protective elements of taking another course of action.
Okay, there's some questions that have come into the Q&A actually. I know I can see another one in chat, but so Stefania's asking if you can explain the gift rule.
One word, sorry?
The gift rule. Could you explain the gifting rule?
Well, there's gifts really there's two styles of gift, I guess. There's a potentially exempt transfer and there's a chargeable lifetime transfer. A potentially exempt transfer typically involves, for example, me gifting something of value to you, Susan. I survived 7 years, and that asset is now completely exempt. Within that 7-year period, it's potentially exempt. So for the first 3 years, if I died within the first 3 years, 100% of the value comes back into my estate and is chargeable to inheritance tax. And then from end of year 3 to the end of year 7, it tapers out of the estate by 20% a year. Now, that's one aspect. That's the simplicity of it. If I gave you cash, that's straightforward. And provided I've got no use for that cash and I don't need to ask for that cash back, then that works from a gift for reservation of benefits perspective. If I gift you an investment property, then there's different things to consider. So you've got things like capital gains tax, because that's a disposal, even though it's a gift for capital gains tax. And in addition, if you're assuming a mortgage liability for me as part of the gift, then there's stamp duty on the mortgage. A chargeable lifetime transfer typically involves gifts that go into a discretionary trust where there is a class of beneficiary rather than a named beneficiary. That still has the 7-year rule, but that typically involves any value above 325,000 per individual being subject to an immediate chargeable lifetime inheritance tax charge of 20%, which arguably is better than 40, but it's still an upfront cost. And then if we've got assets that would be subject to capital gains tax, then we can ordinarily claim rollover relief, but the trust would then assume my original base cost. I think with both of those, the importance of either of those is the interaction with the gift for reservation of benefit rules, which simply state that if you make a gift, it must be outright, and that must result in a total loss of benefit or control over the asset to the person that's giving it.
Okay.
So there's a lot in gifts, and that's why we typically model both sides, really.
Yeah, I mean, Stefania, I think this has been answered. She asked if it can only be money, but clearly it can be something else as well.
Yeah, assets. It can be you can gift anything. It's just got different tax implications.
And yeah, there's a few have come into Q&A, so I'll read one more before we go back to the chat. Jonathan's asked, impossible question to answer, but do you think that a change of government in due course might result in a reversal of the April 2027 changes, which clearly result in huge unexpected IHT liabilities for those caught?
I don't think they will. I think you know, without sort of getting political, I think that, like anybody, people get used to the money that's coming in, don't they? Right. So, you know, somebody then, you know, says, well, we're going to take that away. I think there's a bit of a false promise in there. I think that what I'd like to see, and I sort of get the IHT change for unspent pensions, because really that's being, I think it's unfair, but it's because people have funded pensions on the basis that it's IHT free. But I sort of get the logic that if somebody's just building up a massive pension pot, and that is going to be used as their legacy creation, then I sort of get why the government would go at that. What I don't really understand is this double taxation treatment. You know, the point in the presentation is that the cliff edge really is age 75. You know, you're then into inheritance tax at 40%, and the beneficiary is paying income tax. I think the income tax thing carrying over is deeply unfair. I think the fact that you've got the other changes that don't apply are really unfair. Short answer to the question is they might tinker with it. I don't think they'll get rid of it. I think IHT plays a massive role in revenue generation. Unless a government, somebody in a new party coming in has got the gumption to kind of increase income tax, which is the biggest lever you can pull, then I think they've got to start pulling at the smaller levers in a slightly bigger way, personally.
Okay, yeah. So Howard's asking, what is minimum estate value before you consider providing consultancy service?
I don't think there is a de minimis in terms of the process that we go through. I think that's largely dictated by whether the fee represents good value to the client. You know, because we've dealt with clients that have got no inheritance tax liability, but actually got some value from understanding why and why that might change in the future. So we offer two review services. One is kind of an IHT review light, which is £500 plus VAT, and that really puts clients in the position of understanding what the current position is, but without giving any firm recommendations. The second one is our inheritance tax and estate planning review service, which is charged at anywhere between £1,000 and £1,500, dependent on the complexity. And really what clients get out of that is proper tax and financial modelling, as well as commentary on the different options available for different assets. And I think that's more suited to clients with higher value and more complex estates. I'd say probably, you know, at least £1 million plus, and they might have difficult to give away assets like investment properties and stuff like that.
Yeah, actually, Terence, I think you've just answered Terence's question, where he says, "Sorry, me again. Is there a charging convention for IHT advice?" But I think you've really just covered that.
Yeah, and then typically, you know, our process is pretty much the same for every client. It's just the facts that change. You know, we put them in a position where they understand the current estate. We then give them some ideas and model those ideas in terms of what actions and steps they could take. And the point of that is to really try and narrow down what options the client wants to concentrate on, because it's very difficult to understand all of the different options. If we can triage that and get them to a point where, well, actually, we're never going to make direct gifts because we need the income, and we'd fail to give for reservation of income rules, reservation of benefit rules, then we've got to look down a slightly different route. So that's the client gets put in a position where they know a short list of options, what the consequences of taking those options are, so they can decide to take action, not take action, or think about it. That's essentially it.
Okay, great. Stefania's asked, can we work with a solicitor and refer the client to the solicitor? I'm not quite sure what you mean. I know you said, Mike, that you work with solicitors as well as accountants.
Yeah, look, there's different disciplines. I mean, of course, you can it depends what solicitor clients are being referred to. You know, if they're providing a kind of holistic IHT and estate planning review service, then they're a good solicitor. Typically, where we involve solicitors is where transactions require the input of a solicitor, or whether wills need to be changed or trusts need to be registered, etc. So I suppose the answer is yes, but it depends what your client's looking for. If they're looking for a kind of holistic review and a standard solicitor just deals with the probate side, then, you know, it's death planning versus lifetime planning. We're very much about lifetime planning in conjunction with the death plan, if that makes sense.
Yeah, yeah. So what's Joanne said? What's your thoughts as to what may come up in the budget? Read this. No U-turn. I can't imagine. Can it get any worse? I think, yeah, well, you've given your take on that. Yeah. Yogesh, would the
well,
slides
if you read the reports, I think they're going after wealthy pensioners next, aren't they?
Oh, right. Okay. Yogesh saying, would the slides be shared? So yeah, I'll put them along with the recording in the Know-How Club. So another question in the Q&A, can you simply draw your pensions, pay 20% tax, gift to kids who put in their pension, 20% added, leaving you as a family tax neutral?
Yeah. I mean, if it's genuinely surplus income over normal expenditure, then it's not even within, you know, it's immediately exempt as well from IHT. So yes, that is a strategy that could be used. You know, draw down on the tax-free cash. If you don't need it, give it away. Draw down on the pension, and if you genuinely don't need it and it's surplus, you could give it to children, and they could then put that money into their own pension.
Yeah. So Amit Parikh has put, I think it's more of a statement than a question. He said, currently I advise clients to gift out of surplus income. There is no IHT implications on these gifts. Please refer to IHT 403, page 8.
Yeah.
Sorry.
So that's what we just covered. Yeah.
Okay. So yes, to how surplus income should be calculated.
Yeah, and that's correct to identify the form. You know, the burden of proof to evidence that the gift is genuinely out of surplus income is on the client, and using that form on an annual basis, or the pension or the gifts out of normal expenditure section on an annual basis, doing your kind of personal income and expenditure and showing it as being genuine expense. If you've got that contemporaneous evidence, it's very difficult for HMRC to argue against it.
Right. Okay. Great.
Yeah, okay. So that's a good point.
Right, I can't see any more questions now. We've had loads in there. I think there is really a lot to think about, isn't there, in that presentation? If anybody does have anything, please add it now. Otherwise, as Mike says, we can maybe finish a little bit early, have a little bit of a lunch, more of a lunch break. And in my case, get out and enjoy the torrential rain. But yeah, if you've got anything else, please just type it in now. You've got Mike's email there, so you're happy to be contacted by email, I hope.
Definitely. Yeah.
Great. Yeah, so please do say thank you in the chat, because I think it's been a really, really interesting session. And actually, Mike is going to be doing another session for us. I think we said March, didn't we? So just before the changes come in, to maybe look at some other aspects of this, see if anything's changed in the meantime.
Yeah, and we'll have had a budget in between as well, so it'd be interesting to see whether they make any further amendments to some of the feedback they've had in regard to the rules.
We'll see what happens. It's a little bit of a watch this space thing, isn't it, I think, with this?
Absolutely.
Yeah. But thank you so much, Mike. Really, really informative session. And as you can see all the thank yous coming in, I think really, really useful for everybody.
Thank you.
A terrific webinar. Excellent. Now back to the 38 degrees here. Oh, that must be Tripoli.
Oh,
definitely not here. Anyway, thanks ever so much, everyone, for joining us today. And we will see you all again next week. Okay.
Cool.
Bye bye,
Thanks,
everyone.
Susan. Cheers. Thanks all. Bye bye.
Bye.